Oh, you're right. Oh, yep, I said that too. Oh, look at this. Well, high time served. High time served. I guess you said I came on your live. You gonna come on mine.
What's up, people? Welcome back to Time Served, the channel that serves up the best content daily, and today is no different. We have clips from Judges Shackelford, Boyd, Bryant, and an absolute golden nugget from Texas. First up, Judge Boyd is one of the kindest and most patient judges here on LawTube. However, when you do not report for probation and stand in front of her asking for leniency, those patients go right out the window. And according to Bryant, right through the gray doors. We all have tough times, but that is no excuse. Probation should be the number one priority in your life. Because if you let that go, then there's this downward spiral this inmate just keeps talking about. Let's find out.
Travis Banks in the state.
Defense.
The attorney of record is Joanne De Hoyos. Joseph States in covering.
All right, Mr. Davila, do you have any objections to this attorney standing in for Monica?
Joanne De Hoyos.
I'm sorry, Joanne De Hoyos?
No objections.
No objection.
All right. Mr. Davila, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with Mr. Stateson, and did you understand it?
Yes.
Are you the same Jacob Anthony Davila Jr., who was placed on deferred adjudication in 2018 CR 9921 for the offense of assault, family, choking, strangulation on April 23rd, 2019 for a period of 4 years? Is that you?
Yes, ma'am.
Right, State?
Violated condition number 5 in Bear County, Texas. The defendant, Jacob Anthony Davila Jr., did then and there fail to report to the supervision officer as directed for the months of June, July, and August of 2021 in violation of condition number 5.
How do you plead to that? True or not true?
True, ma'am. The state will waive and abandon the other allegations.
Any objections? Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, sentence you to 10 years and I'm sorry. Just one moment. Let me see if this was reduced because this is listed as an assault, family, choking, strangulation second. Does everyone have that as the charge?
I had admonished him that he was looking at the 2 to 20 based on the enhancements.
All right.
We were not the original attorney. I don't know if it was reduced at that original plea.
All right. Well, I'm looking at the judgment and they have it listed as a second degree, which I think the judgment may need to be corrected. Just give me a moment. On this, it has a range of punishment. It has a second degree. I think there was a hyphen there. There was both something supposed to be there, but it's not there. So probably need to find out more. All right. All right. Did you understand by entering your plea of true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Your Honor. The agreement, should Your Honor choose to follow it, is to deny the motion and alter and amend the conditions to extend for 2 years, to do a new TAP evaluation and for the defendant to remain in custody awaiting that new TAP evaluation, and then to follow the recommendations of that new TAP evaluation, and a 30-day jail sanction and with credit for time served.
Is that the agreement?
It is, Your Honor.
Probation, is this your recommendation?
Well, the original recommendation was for a 12-month adjudicate his term continue with the original. Except for, yeah, he completed it. However, after speaking with the state administration, the state's recommendation was final probation.
Right. So, you want to explain to me why you're not reporting? Because this is a failure to report and you were here, July 2020 for not reporting.
Yes, ma'am.
All right. Do you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Jacob Davila.
All right. So why are you not reporting?
Answer her question.
When I got out on 2020, my mother and my grandpa had passed away, and I kind of went in a downward spiral. But I got back. I got a job. Like when I would say,
The Molina job, looking.
yeah, I have a steady job when I get out, and I could pay the fines and everything.
Well, the issue here is you're not reporting. So and I'm sorry for the deaths that you've had in your family, but did you pick up the phone and call probation and tell them
My
this?
grandmother was talking to my probation officer. Yes, ma'am.
No, you said your grandmother passed.
No, my grandpa and my mother.
All right. So why didn't you pick up the phone and call probation?
I was,
Like, why is your grandmother the one who's calling? She's not on probation. You are.
I had to help pay my mom's funeral.
No, that doesn't explain why you did not pick up the phone and call probation. Obviously, you know you have to report because we've been here before with you not reporting. So why didn't you call probation and say, I've had a death in the family? Why didn't you do that instead of disappearing? So basically, you've been gone since in June, July, and August of 2021. Am I correct?
Yes, ma'am.
So that means that we have not seen you, I guess, until you were arrested. Is that correct, everyone?
That's correct.
So I don't understand why I shouldn't just revoke you because you've been missing for close to 2 years. And you act like you don't know to pick up the phone and call probation. Obviously, you know you have to report because you've had to report before. And this conversation we're having, I am certain, because my mind is a steel trap, that we had this conversation back in 2020. And not only do you not report, you've been missing since August of 2021. So where were you and what were you doing?
I was working, ma'am.
No, you said you had a downward spiral. What does that mean? All right, counsel, if you will take the paper from him.
He did write a letter that he wanted to read to you. And if perhaps if he doesn't read out loud, but perhaps if you wanted to glance at it.
No, I'll let him read the letter, but when you say downward spiral, what do you mean? What have you been doing? Because we have not seen you since August of 2021.
I've been working, ma'am.
Where have you been living?
Oh,
The city you've been living in.
San Antonio,
And whose house is that?
my wife's house, and I've been helping her with the kids.
And
All right,
what's
so
the
where does
place you've been working at?
Oh, I've been working on Old Highway 90 at a Molino shop.
All right, and where does the downward, I'm still waiting for the downward spiral.
I had, if I
Yes,
Your Honor, I believe he may have some anxiety issues. We're
Okay.
gonna do a TAP evaluation in custody, hopefully, if you follow the recommendation. I had asked him about substance abuse issues. He denies it. Although he has been in custody for about 30 days, I understand he would probably test claim because of that. But if the court did wish to ask for a UA test, he's willing to comply, but he's saying that he doesn't have substance abuse issues. He had something test positive back in 2021, but the first test was negative back in 2019. He would not obviously like to be revoked. He did write a letter that he regrets what happened, and it's a statement of taking responsibility if the court wishes to read it.
all right, I will read it if there's no objection to the court reading the letter. Thank you.
So here's the thing, Mr. Davila, and I want you to understand that I'm internalizing everything that you're saying. I understand how devastating it is to lose. I call it the inner circle of the family, because when people in the inner circle and an immediate family start passing, the circle starts getting smaller. And sometimes the grandmother is the matriarch of the family. And once the grandmother passes, then people tend to scatter and things start getting worse. So I understand losing family members, because I've lost many family members. And those are family members that are in the immediate family. I'm not talking about the cousin twice removed. I'm not even talking about the first cousin. So I understand, but you still haven't answered my question. Why didn't you pick up the phone and call probation? Because we've been here before with you're not reporting. And I'm trying to figure out, should you be continued on probation or should you go to prison? Because you're constantly not reporting. And when you don't report, it's not, oh, I was having anxiety, so I missed a month of reporting. You're still out there functioning. You're, according to this and testimony I received, you're doing employment, but you don't report. And then we don't see you for a year. And then you want sympathy from the court and you want to throw yourself on the mercy of the court.
Like when I mean downward spiral, I didn't have a job at that time, but then I got one and I started doing.
So when did you get a job?
I helped pay for my mom's funeral, and after that I got a job.
All right, when was this? Because in the letter I read, it says that you lost your mom at the beginning or close to the end of the pandemic. So
Yes.
what year did you get a job?
2021.
All right, so why didn't you pick up the phone and call probation in 2021?
I had lost the paperwork and all that, but I wasn't on my right mind, man.
No, have you reported to probation in person before?
Yes,
So why didn't you go down and report to probation and say, I'm here, I lost the number?
I think I already had a warrant and I was scared to turn myself in.
All right, so why don't you start with that instead of pretending as though you've lost the number and you don't know where probation is? Everybody knows where probation is. You've at least reported, even during the pandemic, you at least reported to probation once in person.
Yes, ma'am.
So why should I continue on probation? Because it appears to the court that you don't want to be on probation. You don't like being in custody, but you don't want to go to prison maybe, but you don't want to be on probation.
Being here for the 30 days in jail made me realize that my freedom, I need to be out there for my family and help.
Why does it take being in jail make people realize they don't want to be in jail? What do you think jail is?
Detention.
Yeah. So why does it take going to jail to make people realize they don't want to be at the jail? Guess what? I've never stayed at the jail or been a resident of the jail. I've toured the jail with my students to show them what it is, but I've never been a resident. And guess what? I don't want to be a resident at the jail. I don't have to have someone. Hopefully I will be wearing a blue uniform and not red, but I don't want someone to place me at the jail and have me stay there for 30 days for me to say, you know what? The jail is not for me. I don't want to be here. I don't need that experience to know that I don't want to live at the jail. So if I were to continue you on probation, what is going to be the difference?
I will pay my court
It's
fee.
not about the fees. It's about you not reporting.
I will report this time.
And that's what you told me last time. So,
If not, you could give me the max, or if I mess up again.
oh no, here's the thing. You're acting as though you're giving me something that I don't already have the ability to do. The range of punishment on this case is anywhere from 2 to 20 years in prison. So for you telling me, if I'm back again, you can sentence me to the max, I could do that today.
Yes, ma'am.
So I'm trying to figure out, and maybe your attorney can help, what's going to be different and what assurances do I have that you're actually going to report when you're supposed to?
Your Honor, as part of the original recommendation, it did not include a TAP. Travis and I discussed this. We believe that the TAP would actually help possibly find something for him to seek treatment. I'm not certain what that would be, but they weren't asking for a TAP previously. Travis and I discussed that.
All
But
right.
he is employed. As you already said, he did do the TAP. He was on probation 2019, 2020. He didn't, although I think this is a second MTR. He would very much like to keep probation, keep his job. We would ask that maybe perhaps you consider a longer sanction and considering continuing him on probation.
All right. Anything else you want to say before I make my decision?
I will do better decisions this time.
I'm sorry, what?
I will do better decisions this time, man.
And has he had a gang evaluation? Are there any gang affiliations with you?
No,
What is with the tattoo of the cross or the plus sign?
I was gonna be a tattoo artist and cut hair.
Right.
It was for,
And what's the tattoo on the eyelids?
I was a guinea pig.
I'm sorry?
I had a tattoo artist. We're supposed to do cut hair and do tattoos, and I was like a guinea pig. Like,
So you still haven't told me what are the tattoos on the eyelids because you keep blinking them and I really can't see them.
I'm like kind of ashamed of them. Like I regret them. I regret the tattoos.
So what does it say?
It's small. You can't really see.
Mr. Statson?
It's
What are-
like scribbled. You can't really tell what it says. It's like makeup.
What do the eyelids tattoos say?
Game over. That's my mom.
He says game over, but it does spell game over, but he says it's because his mom passed away.
All right. Yeah, I'm not understanding that and I'm not believing that. All right. So we're going to do a gang evaluation. I'm going to deny the motion, alter and amend conditions. It's going to be the UA hotline. I'm going to want a gang evaluation. And we're going to do GPS,
Yes, ma'am.
and that'll be partial for work. And there's to be a TAP evaluation in custody. And you're to follow all recommendations for TAP. And if he is not eligible for gang supervision, then I'm going to want probation to do field visits at least once a month until further notice. All right, let's do that. Intensive supervision. Probation, is there anything else he needs?
How long does it expire for of this year?
Oh, I'm extending him because he hasn't given us full probation. I'm extending him for 4 years. So you're going to give me full probation and you're going to abide by this contract from here on out. Maybe I didn't tell you this, but I know I probably did. But from here on out, everything that you do, you need to ask yourself, because this result in me going to prison for 20 years.
Yes, ma'am.
If the answer is yes, you shouldn't do it. If the answer is maybe, you shouldn't do it. Do you understand?
Yes, ma'am.
If he misses reporting, I want a motion to revoke filed immediately. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome.
Isn't she great? Next up, we take a look into Judge Victoria Shackelford's courtroom. And we have 2 cases from her docket today. The first one, there's a lawyer and a disgruntled dad squaring off, and there are fireworks to be had. And the second, my man fell asleep on Zoom, so Judge made him come in person. Oh boy, what is she gonna do to him? Let's find out.
Oh, yes. All right. This is Edward Van Maren versus Jasmine Davidson. Mr. Van Maren, can you tell me your name? You're muted.
Apologies. My name is Edward Van Maren.
Okay. And Mr. Jaffe?
Your Honor, good morning. Attorney Brent Jaffe on behalf of Jasmine Davidson, Your Honor, asking the court respectfully if I could waive my client's appearance for today's hearing. I have been in regular contact with her, and again, I'm asking that I can waive her appearance, please.
Okay, it's waived. So we're here today because Mr. Van Maren filed this suit. It got removed from small claims to civil. And then there was no progress on the case. I got an appearance filed by Mr. Jaffe. So now everyone's here. It's scheduled for an entry of a default judgment, but the parties appear. So that's not appropriate. I've seen all of these charges or all of these allegations that were made ultimately by both parties. So do both of you have everything you need to proceed on this case?
Your Honor, I as things stand, I plan on taking Mr. Van Meren's deposition. I do think that this is a frivolous lawsuit. I'll put it like this, Your Honor. I have history with these parties, in particular with the custody matter on more than one occasion, and PPO matter that was granted on more than one occasion against Mr. Van Meren with regards to my client. This is further harassing and narcissistic tactics, if you will, and intimidation tactics, if you will, to make my client's life difficult. And what's insane to me, Your Honor, is that they have a minor child together, and this is what he does. It's absolutely disgusting, actually, but that's a different story. So, Your Honor, as things stand, again, I'm prepared to take this man's deposition in terms of proceeding forward. And again, Your Honor, this is about as frivolous and as con artistly oriented as it gets. So that's my position today.
Mr. Van Maren, do you have a response?
Yes, Your Honor. First of all, as far as the PPO goes, I have proof that the allegations are entirely false, that the incident never happened. I also have recorded many conversations between the defendant and I, in which she promised to repay the money that she stole from me. I can even file for subpoenas and conversations that she'd had with other parties for proof that she'd stolen from me. Bring
it on, my man. Bring it on.
I have statements from multiple parties to prove my whereabouts on the night in question.
All right, well, we're not here for a PPO. I'm a district court judge. So I'm here over allegations of money due and owing. That's all we're here for.
Correct, Your Honor.
So I mean, as for depositions, I don't want, this is a district court case. Discovery is at my discretion, and I'm not inclined to just let the parties go wild on discovery. I'm just not. Mr. Van Maren, when you call this court and you talk to my staff, you do so respectfully, sir.
I understand.
I mean it. I have notes in this ROA about you screaming at my staff and being disrespectful to the court staff. These are human beings that come to work to do a job. Be nice. Be patient.
I understand. I apologize.
I am not allowing on discovery. I'm given 30 days. No request to admit will be used in this case.
I'm sorry, Your Honor. What is the request to admit?
Your Honor, within the 30-day time frame, may I set up his deposition?
You know, deposition is okay, but the request to admits are an attorney or a party can send the other party questions or requests for them to admit to things. And if they don't answer them, the court rule says they're deemed admitted. I don't like the use of them against improper parties. So there will be no request to admit. We're gonna come back. I'm not, witness lists are due. August 24th. Any motions are also due on August 24th. Answers to those, any motions, including dispositive motions, are due on August 24th. Then we have answers to dispositive motions must be filed by, hold on, I need a calendar. By September 7th. And I'm going to hear all of the motions on, wait, I can't do 9/21, right? Correct. All right. It'll be 9/28. So we're going to see each other next on September 28th. We'll make sure you get a copy of this in the mail.
Your Honor, in terms of communicating or corresponding with Mr. Van Buren, could we just place on the record that he's okay with me communicating with him via email or another means? Because I'm finding this very difficult, actually. So we could perhaps question him or ask him what the best way for me to communicate with him would be.
How should he communicate with you?
Email or directly via cell phone is fine.
And then, Your Honor, if you
All
could
right.
place an email on the record, I'd appreciate it.
Well, Mr. Van Mock, hold on. Just hold on one second.
The 3 noted violations.
All right. Mr. Callahan, can you tell me your name?
Juan Callahan.
Did you go over this program violation advice rights with your attorney?
Yes, ma'am.
All right. You understand if you enter a plea, you're going to be waiving your right to a hearing.
Yes, ma'am.
There's an allegation that you were removed from IOP on July 10th for falling asleep on Zoom. To that allegation, how do you plead?
Yes, Your Honor.
Okay. The second one is that you failed to report for testing on July 16th. To that allegation, how do you plead?
Guilty, Your Honor.
To the allegation that you weren't present in IOP on July 18th, how do you plead?
Guilty, Your Honor.
All right, I'm going to accept the pleas as knowing and voluntarily given. Dewan.
I mean, Your Honor, there's really no only best thing that I can say is my communication should have been more like I should have been more communicative, but
You shouldn't have fallen asleep
Well,
in
that-
IOP.
no, so that I completely understand that, but
That is unacceptable.
so yes, I know.
That one is unacceptable to me. Like, these people are all in that group for a reason. And like, that is not a good look.
That's why I've been trying to go into person, Your Honor.
You should.
That's I am. But I was just super exhausted. I mean and then sitting there, I just dozed off. That was I take full responsibility for that. And missing up the testing, it was just exhaustion, honestly. And then it was a Sunday. I didn't wake up till 9:30. So I checked the color at 4 in. When I got home, and I planned on making it in, but I just didn't.
And then you missed IOP again.
So that one, yes,
That's where the communication part comes in.
That's where I should
Judge.
communicate.
It's our issue, and you should have called and said, I got a problem. They would have worked all of that out. And I don't think we would have been discussing.
And the one you should know by now, though, like by now, like if you communicate with everyone, things go a lot smoother
Yes,
for
I
you.
do know that.
Sometimes if you communicate and you have a rational, explanation, sometimes you don't even get violated. You just get excused. right? But when you go about it the wrong way, you end up in front of me. And like, you're past that. Like, you've been in IOP, you've been in therapy for a while now. Like, you gotta get past that.
I do know that communicating is the best option. I don't know what I was thinking about not communicating.
And like, your job is nothing matters if you can't be in recovery.
I understand that, Your Honor, but I mean, I'm no good at recovery, and I just want to keep everything afloat. So I'm a normal hard worker. That's all I can say. Like, I just work hard, and it just catches up with me now.
Well, we talked in the back. I mean, DeJuan, this is your 11th violation. Like, you're to the point, like, you've got to comply. You have got to get your stuff in order in this program. Like, you have to. 11? It's 11 violations. Like, I keep waiting for you to turn the corner and not like acclimate, so I don't have to constantly see you like this. I enjoy seeing you, but I don't want to see you like this all the time.
I don't want to see me like this either.
All right. Look, you're going to do a day.
You want another pre-trial conference?
You have to. You fell asleep in IOP.
No.
You missed testing and you missed IOP after you fell asleep in IOP.
So
And you didn't
take
communicate.
2 months?
I'm not giving you 2 days, which is a recommendation. You're also going to do an essay, and the essay is going to be on communication, planning ahead, and your priorities, and you're going to present the essay at the next status hearing.
You mean talk in front of people?
Mm-hmm. Yeah. Yeah, you're going to do that, DeJuan, and you're going to write it, and you're going to like really think about it. You got to do the day. You got to do the day.
So I'm going to miss work and everything.
DeJuan, it's your 11th violation. I always let you turn yourself in. I can't, there's got to be an immediate sanction. It's a day.
Yeah, for the phone call, so.
Yes, yes, absolutely. He can make phone calls. He can do what he's got to do. All right. Ms. Johnson.
Oh, he gone. Wasn't that awesome? Up next, we all know how great it is to see Judge Bryant go at it with defendants and lose her cool on her docket. However, here at Time Served, I have always, since day one, enjoyed showing the other side of Judge Bryant. And in this case, we see how thankful this one inmate is to have Judge in his corner. And then I'm going to roll right into the main event, and it is a gem. I have never seen an inmate so excited and happy to rush through his guilty plea. I promise it will not disappoint. Make sure you hit that like and subscribe and set your notifications so you never miss the Time Served daily uploads. See you later, nerds. Enjoy the rest of the show.
All right, so then this is case number 2. No, that's not. Hold on. Oh, case number 23-449-0001. The People versus Terry Alexander. Defendant is charged with 1 count of breaking and entering illegal entry without owner's permission. Today is the date set for strike that. Mr. Alexander is brought before the court by the jail on a tether violation that was submitted by Sergeant Spencer. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Terry Alexander. Mr. Alexander, sir, please tell the judge your full name.
How you doing, Your Honor? Terry Alexander.
All right. I'm well, Mr. Alexander. Thank you. So as we said off the record, it appears from the tether violation submitted to the court that Mr. Alexander, that the violation report was submitted because Mr. Alexander appeared in the Third Circuit Court
on a violation of probation warrant, and he was taken into custody while he had on the tether. And that appears to be the only violation, because of course you don't need on the tether if you're in jail. So the court would be inclined to dismiss the violation and continue the bond. Ms. Ritter, do you read it the same way?
I do, Judge. I agree with the court.
Now, Ms. Stevenson, I do have a question. What's the status of felony hold that took him into the Wayne County Jail?
That's actually a probation matter, Your Honor, and I understand the probation violation has been dismissed as well. So we would actually be asking that the tether in this matter be removed. Mr. Alexander, I believe, presents absolutely no risk of flight. I think he, rather than going to court, I think he turned himself in at the jail to take care of the probation violation matter, Your Honor. So he knows where he's supposed to be, and he gets there when he's supposed to be there.
Oh, the tether violation notice says he went to court for violation of probation.
Yeah, he went to court after he turned himself in at the jail.
Oh. Well,
is that right, Mr. Alexander? Is that
what it says? Because it says the subject was taken into custody from court. From court, it says.
Yeah, no, it was from court. I had to go to court for the probation violation. Then my judge wanted me to pay $100. I didn't have the money on me right then and there, so I had to come in jail and go through the process.
Right. Okay.
Well, thank you for correcting. I appreciate that. I apologize, Your Honor. So, again, no risk of flight because he goes to court when he's supposed to.
Yeah, I agree with that. Ms. Ritter, I would be inclined to remove the tether. Any objection from the people?
Judge, if the court is inclined to remove the tether, I'm just asking that the no contact order stay in place for the complaining witness in this matter in front of this court.
All right. Mr. Alexander, the court is going to again dismiss the tether violation and also remove the tether. You will still have no contact with the complaining witness. Who is the complaining witness?
I don't know.
Hold on, Mr. Alexander.
I'm talking to the prosecutor.
I'm sorry.
The complaining witness is Janice Greer.
Oh, okay. All right. You will have to have no contact with Janice Greer or the location of the alleged offense, which I'm not going to put on the record, but it will be in your paperwork to the jail. I'm not going to put Ms. Greer's address on the record because we're live streaming, but it will be in the jail. I just realized, are the red lights on in the courtroom?
Yes, Your Honor.
Okay, I don't see them. Okay. All right, so Mr. Alexander, they should release you today, okay?
Yes, ma'am. And I want to thank you. Thank you so much for giving me a chance. Nobody gave me a chance. I just want to thank you, Your Honor.
Oh, you're welcome, Mr. Alexander. Everybody deserves a chance.
I've been treated so unfairly for some things I haven't done. I really want to thank you so much.
All right. Well, you're so very welcome, and they will let you out today. So you have a great day and stay safe, okay?
Yes, ma'am. I appreciate you so much.
Okay. Thank you. All right.
Welcome to the 196th District Court. Court is in session. This is cause number 2021 CR 6903W, State of Texas versus Valentine Villalobos. We're here today for a plea. We're conducting this plea via video conference using the Zoom application. We are also using YouTube to live stream the proceedings to keep the hearing public. The time now is 10:38 a.m. on the 9th day of August, 2021. These proceedings are official. They're on the record and they're being recorded by the official court reporter. Counsel and all present are instructed to act as though you're in court. We're all instructed not to record the proceedings. And if I could have the attorneys make appearances, starting with the state of Texas, please.
Austin, stop for the state.
Bo Wood, on behalf of Mr. Villalobos, he is present. We are ready, Your Honor.
And Mr. Wood, there was something about the name for your client. Can you put that on the record for us real quick?
Yes, if we could, Judge. He is in his information and his docket shows him as Valentine without an E at the end of the first word. And he says his first name is actually Valentine, just like the holiday during the year, Valentine with an E, Villalobos, and he's actually Junior. So every document he signed Valentine with an E, Villalobos Junior. We'd ask the court to allow that correction.
What I can do is, we're on Zoom, so trying to change it on Adobe Sign's a little difficult, but once I get down to the office where I can physically have the paperwork, I can append the information with the correct name. It's not an amendment, so we don't have to do delays or anything like that. I'll put the proper name of Valentine Villalobos Jr. on there. But sir, are you Valentine Villalobos charged by information with theft under $2,500 enhanced? Is that you, sir?
Yeah, I know, my wife had told me $100.
Mr. Villalobos, I'm addressing you. Is that you, sir?
Yes, sir, Honor.
I'm going to use a function of Zoom called share screen. I'm going to show you the show you the information in this case. Give me just a minute.
Yes.
Try this again. A little technical difficulty, but there we go. All right. I'm showing you on the screen the information. Are you familiar with this document, sir?
The name is not correct, sir.
I know we already went over that, but are you familiar with this document, sir?
Right now, yes, sir.
Did you go over this with Mr. Wood?
Yes, sir, Honor.
Did you understand it?
Yes, sir, Honor.
And Mr. Wood, do we waive reading of the information?
Yes, Your Honor, we'll waive reading.
In fact, actually, let me scroll down to another document that covers that anyway. Mr. Villalobos, I'm now showing you a document called the waiver of indictment, waiver of reading the information, and waiver of certain time delays. Are you familiar with this document?
Yes, Honor.
Did you go over this with your attorney?
Yes, I did, Honor.
And did you understand it?
Yes, sir, Honor.
Here in the middle of the page is an electronic signature. I'm using my cursor to circle around. Is this your signature?
Yes, sir, Honor. That is correct. Yes, sir, Honor. That is correct.
By signing this, hold on now, let me finish. By signing this, you're telling me that you understand normally this type of offense has to go to the grand jury for an indictment, that you want to waive that proceeding. Is that true?
No, it's, yes, dismiss. My attorney knows what I'm trying to say. Yes, sir.
Hold on,
you don't want to trial.
Hold on, Mr. Wood. Let me talk to him real quick. All right,
Yes,
Mr. Villalobos, when you signed this document right here, you said that you wanted to waive going to the grand jury for an indictment, that you just wanted to proceed on the information, which was that other document I just showed you. Did you understand that when you signed this?
Yes, sir, Honor. Yes, I did, Honor.
Okay, so is that how you want to, hold on, is that how you want to proceed?
Yeah, I understand that. Guilty, sir. Guilty. If everything's
I'm not
guilty.
even close to asking you that question, Mr. Villalobos. Let's put on the record, Mr. Wood, let me get out of here. Mr. Wood, have we already had a psyche valve for Mr. Villalobos?
Yes, Judge, earlier, due to, I don't believe his attitude is incorrect. It's just he's so eager to answer that he gets ahead of himself.
Let's talk about the psyche valve. Was there a psyche valve that was conducted?
There was a competency evaluation done, Judge, and he was found competent.
Okay, so
And if I may very quickly, Mr. Villalobos, he's asking you, do you wish to proceed today, or do you wish to have a grand jury look at your case and we come back another day?
No, sir. No, sir. No, sir. No, sir, attorney. No.
All right, so Mr. Villalobos, I'm going to put it back on the screen again using share screen. The document titled waiver of indictment. So when you sign this right here, I'm using my cursor, you're saying you wanted to waive indictment, that you didn't want to go to the grand jury, you don't want an indictment, you just want to proceed on the information, which is that other document I showed you. Did you understand that when you signed this document?
Yes, sir, Honor. Yes, sir, Honor.
Okay.
Yes.
Now that we filed the information, we could read it out loud to you word for word, but you're telling me you don't need to do that either, that this signature tells me You understand the information. We don't have to read it out loud. Did you understand that when you signed this?
Yes, Your Honor. Yes, Your Honor. Yes, Your Honor.
Furthermore, now that the information has been filed, you have 2 time delays under the law. One is for 2 days, one is for 10 days. But you're telling me that you would rather proceed today and not wait those delays. Did you understand that when you signed this?
Yes, Your Honor. Yes, Your Honor.
All right, I'm going to get out of share screen for that document. I'll note that there's a discovery acknowledgement that's been signed and dated by both sides. It was signed on August 4th of 2021. This is when Mr. Villalobos' case was at our jail court. So jail court Judge Canales has signed it back on August 4th, 2021. I'll accept that and make that a part of the record. Then Mr. Villalobos, I'm going to go back into share screen again. I'm going to show you another document. Having technical difficulties again today on this stuff for some reason. Try it again. All right, Mr. Villalobos, I'm now showing you a document. It's called the Defendant's Consent to Plea by Video Conference. Scrolling down and using my cursor to search my electronic signature. Is this your signature, sir?
Yes, it is, Your Honor. Yeah, it is correct. Yeah, it is correct.
Signing this, you're telling me 2 things. One, you understand that normally this type of hearing has to go before me live and in court, but that you're consenting to do this hearing by video conference. Did you understand that when you signed this?
Yes, Your Honor. Yes, Your Honor. Yes.
And secondly, your electronic signature here, as well as all of your other electronic signatures on the plea packet in front of me today, you're telling me that those are valid as if you personally signed them. Did you understand that when you signed this?
Yes, Your Honor. Yes, sir, Your Honor.
I approve the consent and I make it a part of the record. We are still in share screen. I'm now switched over to and scrolling down to a document called the Court's Admonishments. I'll scroll through because it's several pages. But are you familiar with this document, sir? Mr. Villalobos, are you familiar with this document?
Yes, Your Honor. Yes, sir, Your Honor.
Did you go over this with your attorney?
Yes, Your Honor. Yes, sir, Your Honor. Yes, Your Honor.
Did you understand it?
Yes, sir, Your Honor. Yes, sir, Your Honor.
Bottom of page 4 is electronic signature. Is this yours?
Yes, Your Honor. Yes, sir, Your Honor.
Now share screen. By signing the court's admonishments, you're telling me that you understand the court's admonishments and that you understand the rights that are contained within it. Is that true?
Yes, Your Honor. Yes, Your Honor. Yes, Your Honor.
And that you want to give up those rights. Is that true?
Yes, Your Honor. Yes, Your Honor.
And the rights that you're giving up is the right to a trial by jury. You have a right to confront the witnesses against you. You also have the right to remain silent, which includes the right not to incriminate yourself and not plead today. Did you understand that when you signed this?
Yes, Your Honor. Yes, Your Honor. Yes, Your Honor.
By signing this, you're also telling me you understand the consequences of a plea and the sentencing range for the offense, which is anywhere from 180 days to 2 years in the state jail and up to a $10,000 fine. Did you understand that when you signed this?
Yes, sir, Your Honor. Yes, sir, Your Honor. Do you talk Chinese, sir?
Waivers, hold on. I approve the waivers that are contained within the court's admonishments and make them a part of the record. Sir, we're going to go back into share screen. I'm going to show you your plea bargain in this case. I'm going to go over it with you. First off, are you familiar with this document?
Yes, Your Honor. Yes, sir. Everything's correct, sir. Yes, sir.
Go over this with Mr. Wood. Did you, Mr. Wood, talk about this, sir?
Yes, we did, Your Honor. Yes, we did, Your Honor.
Understand it.
Yes, sir, Your Honor. Yes, sir, Your Honor. Everything's correct. Yes, sir.
There's an electronic signature to the left. I'm using my cursor to circle around. There's another one to the right. I'm using my cursor to circle around. Are these your 2 electronic signatures?
Yes, sir, Your Honor. Everything's correct, sir, Your Honor. Yes, sir, Your Honor. Yes, sir, Your Honor. Everything's correct, sir.
This details for me your agreement with the state as far as punishment is concerned, and I'll let you know if I'm going to follow this prior to the entry of your plea. It says that you have a state jail felony conviction, but under the provisions of Penal Code 12.44, Class A misdemeanor punishment will be assessed with 180 days. There's no, in the Bexar County Jail, there's no fine, there's no application for community supervision, deferred adjudication, taken in consideration for dismissal as a resisting arrest case. And one of your signatures, the one on the left, waives your appeal. Is that your understanding of the agreement, sir?
Yes, my honor. Yes, sir, my honor. Yes, sir, my honor.
Counsel, is that your understanding as well?
Yes, it
Yes,
is,
sir.
Your Honor.
I'm going to get out of share screen. Mr. Villalobos, I'm not bound by a plea bargain. I do not have to follow this. Do you understand that?
Yes, sir, my honor. Yes, sir, my honor.
But if I do follow the plea bargain, then you lose your right to appeal. Do you understand that?
Yes, sir, my honor. Yes, sir, my honor. Yes, sir, my honor.
That's true unless I grant you permission to appeal or unless certain motions are filed and ruled upon. Do you understand that?
Yes, sir, my honor. Yes, sir, my honor. Yes, sir, my honor.
Counsel, any such rulings in this case?
No, Your Honor.
I do not follow the plea bargain, then I will allow you to withdraw the plea and will proceed to trial as if this hearing never occurred. Do you understand that?
Okay, because I also want to see if we can get the stipulations.
Understand that, Mr. Villalobos?
Yes, sir, my honor. Yes, sir, my honor.
Harmful contact?
Well, note again, one of your signatures on the plea bargain waives your appeal. Are you a citizen of the United States?
Yes, sir. I serve my country also, sir, my honor.
Okay.
If not, then a plea of guilty or no contest to the offense of serious adverse effects on your immigration status. And I'll note that you're certified in the court's admonishment that you are an American citizen. Counsel, do you believe that your client has a factual and rational understanding of the charge pending against him?
Yes, Judge.
Do you believe it has been able to assist you in the defense?
Yes, sir.
Do you believe it is mentally competent to waive the right to enter a plea here today?
Yes, Your Honor.
Sir, to the offense that's listed on your information, how do you plead? Guilty, not guilty, or no contest?
No contest. No contest.
And that you can still be found guilty under a no contest plea.
No contest, sir, my honor.
That doesn't answer the question.
I'm sorry about that.
Do you understand? Do you understand that you can still be found guilty under a no contest plea?
Yes, sir. Yes, sir, my honor. Yes, sir. I know. Yes, sir. Yes, sir.
Other than the plea bargain, did anyone promise you anything in exchange for your plea today?
No, sir, my honor. No, sir, my honor.
Did anyone force you or coerce you to plead today?
No, sir, my honor. No, senor. No, sir.
After going over this case with your attorney, do you believe that pleading here today is in your best interest?
Yes.
Cool. Yes, yes.
Hold on, Mr. Boyd, let him answer. Do you think it's in your best interest to plead today, sir?
Yes, sir, my honor. Yes, sir, my honor. Yes, sir. Yes,
Does the
sir.
state have anything to offer to support the plea?
The state offers State's Exhibit 1 and all attachments.
We've had an opportunity to view it and have no objections.
It's admitted. I reviewed State's Exhibit 1 and attachments prior to getting on the record and find that it is sufficient to support the plea. Sir, I find that your plea was freely, intelligently, and voluntarily made, that there was sufficient evidence to support the plea, and that you're mentally competent to enter into such a plea. I find you guilty, sir. Mr. Wood, is there any legal reason as to why your client cannot be sentenced today?
No legal reason we would agree to waive a PSI, Judge.
Being no legal reason, in accordance with the agreement with the state, sir, you have a state jail felony conviction, but under the provisions of Penal Code 12.44a, I'll impose Class A misdemeanor punishment of 180 days in the Bexar County Jail, and I will give you credit for time served. Taken in consideration as another offense. And I'm just going to dismiss it. This is cause number 662584, resisting arrest. Sir, this is a plea bargain case. I filed the plea bargain, so you do not have the right to appeal. You do not have the court's permission to appeal. I'm making a certification of this for the record. I'll file a copy. I'll provide a copy of the certification to your attorney to provide to you. And this now concludes the hearing. And unless there's anything else from either side.
Nothing from the state.
Nothing from the defense, Judge.
All right. Good luck to you, sir. This now concludes the hearing. We're in recess.